When Judge Carol Kuhnke dismissed my lawsuit against Maria Viggers, I was very undecided on whether or not to appeal, because of course I knew I was right. I knew Judge Kuhnke's perverse rulings are so contrary to Michigan law and so contrary to any notion of justice. But at that time there was a lot going on in my life, and therefore I wasn't sure of whether I would be able to cope with learning the rules of the appellate process and engaging in such process at the same time that I was continuing my litigation against Al Pacha. One issue that I was dealing with at that time has to do with my grand uncle in Spain. I was always very close to my grandfather, but he died in year 2000. Therefore, to me, having contact with my grand uncle felt like a continuation of having my grandfather. However, because of my work visa, I was unable to travel anywhere outside the United States, and therefore unable to visit my grand uncle in Spain. During my grand uncle's last few years, my mom played the role of ambassador between my grand uncle and me, because she was able to visit my grand uncle in Spain and then come to the United States. She was also the translator, because due to my grand uncle's advanced age, he could barely hear me when I called him every week, usually on Saturday. But my grand uncle could hear my mom's words much more easily. Before the University of Michigan made or engaged in all its dirty actions that involved the withdrawal of the offer of employment, I was planning to negotiate with the university the possibility of taking some unpaid time off soon after beginning my employment with the university, because with the work visa that the university was going to sponsor, I will be able to visit my grand uncle in Spain. But then the unexpected events that I described in the first segment took place, and therefore I have to engage in the litigation against Maria Viggers, and then, as it turned out, also against Al Pacha. That means I knew I will be unable to visit my grand uncle anytime soon. My grand uncle died in March of 2016, few days prior to Judge Carol Kuhnke's ruling dismissing my lawsuit against Maria Viggers. When I talked with my family about the hard time I had about deciding on whether or not to appeal, my family always told me, "We are going to support you no matter what decision you make, and the decision is totally up to you because you are the one dealing with the hardest part of this situation." And I decided to appeal in the lawsuit against Maria Viggers 2 or 3 days prior to the deadline. And I remember that once I communicated to my mom my decision that I was going to appeal, she was glad. She told me, "I didn't want to influence you in either direction, but I am glad that you decided to appeal." And in hindsight, I think that was a great decision, because as I will find out later, Judge Carol Kuhnke was going to be as corrupt in my lawsuit against Al Pacha as she had been in my lawsuit against Maria Viggers. As I was still litigating my lawsuit against Al Pacha, I was also working on the filings for my appeal against Maria Viggers. Then, 7 days after my lawsuit against Al Pacha was closed in trial court, I filed in the Michigan Court of Appeals every document I needed to file in order to get that second appellate process started. The filings included my brief on appeal. The brief on appeal is the most important document in an appellate process. That's the document that the judges in a court of appeals read when they review a case, and that is where the litigant develops the facts of the case with references to the evidence that was filed in trial court, and the litigant also develops his legal arguments with the points of law that support his position. The fact or the complexity and the work and detail involved in the drafting of an appellate brief is reflected by the fact that the deadline for filing a brief on appeal is the longest deadline in an appellate process. In the case of Michigan, if the litigant knows what the court rules, he or she will be able to postpone the filing of his brief on appeal for over 5 months, starting from the day his or her lawsuit was closed in trial court. But again, to do that, you will need to know the court rules. There are attorneys who supposedly specialize in the drafting of an appellate brief, although I don't want that to intimidate you. For example, in the matter of Al Pacha, when I brought it to the Michigan Court of Appeals, his law office added a third attorney, but the brief they ended up filing was pretty much a copy-paste of things they filed in trial court. However, I just need to emphasize that it still requires so much work and attention to detail if you want to file a robust brief on appeal. At that point, starting from August 24th of 2016, it was just a matter of waiting until the Court of Appeals will go through its backlog and eventually review my 2 cases. In the meantime, a lot of things happened. As I mentioned in the first segment, Maria Vigors started harassing me by making her supposedly anonymous phone calls since early 2015. And I say supposedly anonymous because many of her phone calls coincided with events that happened at the University of Michigan in connection with Maria Vigors, and once I was terminated, many of the phone calls happened in the eve of court hearings regarding my lawsuit against Maria Vigors. Even after Judge Carol Kuhnke dismissed my lawsuit against Maria Vigors, the phone calls continued, because that's what happens when corrupt judges leave criminals unpunished. The criminals continued with their illegal activity. Apparently, this inept Judge Carol Kuhnke has never run into the idea that impunity confirms the disposition to commit crimes, and it always invites greater crimes. On September 16th of 2016, Maria Vigors called me again, except that this time she forgot to conceal her phone number. That allows me, for the first time ever, to capture evidence that Maria Vigors was violating the personal protection order even after the police served it upon her. Technically speaking, there are 2 ways to throw this criminal Maria Vigors in jail. The first one is insofar as her violation constitutes criminal contempt, which according to the Michigan court rules is punished by incarceration. That violation that Maria Vigors incurred also constitutes or is classified as a felony in the Michigan Penal Code. As soon as I received these 2 phone calls, I contacted the police or law enforcement to report the violations by Maria Vigors. I was still speaking with the police officer when my cell phone got 2 additional phone calls. These were 2 silent voicemails originating from a hair salon located nearby from where Maria Vigors lives. I presume that as soon as Maria Vigors realized that she screwed up by not concealing her phone number when she violated the personal protection order, she drove to the hair salon and asked for permission to use their phone line in her attempt to obfuscate the violation that she had just committed a few minutes earlier. Since I didn't want to interfere with the processing and investigations by law enforcement about the violations by Maria Vigors that I reported, I put on hold any filings regarding the criminal contempt proceedings that I was about to bring against Maria Vigors. Meanwhile, I drafted and filed in the Judicial Tenure Commission my complaint against Judge Carol Kuhnke. The Judicial Tenure Commission does not reverse any rulings made by a judge. That will be within the scope of the Court of Appeals or the Supreme Court. Instead, filing anything in the Judicial Tenure Commission is for the purpose of denouncing a judge's misconduct. And as I have been explaining in this segment, there was so much to denounce about Judge Carol Kuhnke. Her misconduct, erraticism, lack of diligence, corruption, and other attributes that are the opposite of what the Judicial Tenure Commission calls the appearance of justice. I should point out that I didn't limit myself by just filling the grievance form that the Commission makes available to the public. Instead of that, or instead of just doing that, I drafted and filed a full-fledged complaint, such as the ones that the Commission files when it decides to proceed against a judge. My complaint against Judge Carol Kuhnke contains full references to evidence that was made available to the Commission, as well as the case law that supports the point I wanted to make in my complaint. Therefore, the investigation by the Commission will consist only of verifying that what I say is found in the evidence and that the case law that I cited actually exists and is applied in the matter that I mention it in my complaint. The Commission is very secretive or very hermetic and obscure regarding its proceedings or its investigations. It is impossible to obtain any information from the Judicial Tenure Commission other than when the Commission has decided whether or not to proceed against a judge. Several weeks later, the detective in charge of investigating the violations by Maria Viggers notified me that the general attorney or prosecutor declined to issue a warrant against Maria Viggers. Therefore, at that point, I began filing in court the documents regarding the criminal contempt proceedings against Maria Viggers, also known as motion to show cause. For reasons that make no sense, the matter of the criminal contempt proceedings against Maria Viggers was assigned to Judge Timothy Connors, instead of being assigned to Honorable Julia Outside, the judge who granted the personal protection order. I wish Honorable Outside had presided this matter because, based on my experience with the judges from the Washtenaw County Trial Court, Honorable Outside is the only judge who performs her judicial functions with responsibility, whereas by then I had heard negative comments about Judge Timothy Connors, and, well, if you've seen the previous segments, you know why I have such a terrible concept about Judge Carol Kuhnke. Apparently, Maria Viggers received the notification for the hearing just prior to Thanksgiving holidays, which in 2016 were on November 24th and 25th. The notification must have agitated Maria Viggers as well as my father, because on November 25th, my father began drafting a series of false accusations of crimes in preparation for his request for a personal protection order against me. In doing so, my father violated Michigan law and he committed abuse of process. The purpose of a personal protection order is to protect somebody who is being harassed or whose safety is imperiled by the unlawful activity by one or more individuals. But just because I was filing criminal contempt proceedings against Maria Viggers, that does not mean that I represent an actual danger to my father. So he was just retaliating for the fact that I was trying to obtain justice after Maria Viggers violated multiple times the personal protection order that was issued against her. On November 21st of 2014, I emailed my father because it was his birthday and he was becoming 60 years old. That was a time when I was seriously considering to mend my relation with him. Therefore, it is so ironic that 2 years, 4 days later, my father was fuming and breaking Michigan law just because he wanted to retaliate against me for commencing a court proceeding against his criminal wife, the same criminal who falsely accused him of domestic violence back in 2014 during their divorce proceedings. I will make additional remarks on this issue. For now, I will point out my father's allegation that I sued Judge Carol Kuhnke in what my father calls the Detroit Judge Circuit. I presume that he meant the Judicial Tenure Commission because that is the entity in charge of handling the judge's disciplinary issues and because the commission is physically located in Detroit. Given what I mentioned a few minutes earlier about how secretive and hermetic the Commission is in regard to its investigations and processes, it is quite interesting that even my father knew that I filed a grievance against Judge Kuhnke. At the time my father made his statement, the Commission hadn't even notified me about its decision, which was that they didn't find anything inappropriate in Judge Kuhnke's conduct. But as we can see from my father's statement, he appears to know already the outcome. Therefore, this statement made by my father implies that Judge Carol Kuhnke must have disclosed the matter to Finley the idiot, who in turn revealed it to Maria Viggers and or my father. That is indicative that some corrupt judges engage in improper contact with one of the parties or their attorneys. Coincidentally, the party involved is the one whom the judge favored through the unprincipled rulings. It is not difficult to imagine Judge Carol Kuhnke and Finley the idiot doing a mockery in the sense of, oh, look at this pro se litigant filing his grievance with the Commission and failing again, because Michigan loves anybody who's powerful and we are powerful, ha ha ha. That's the only thing these people can mock about a pro se litigant who has integrity, unlike them. Whereas it appears that Judge Kuhnke voluntarily disclosed the matter of the Judicial Tenure Commission, on November 25th, another incident happened that was disclosed much to Judge Kuhnke's regret. What follows involves a tragedy. The tragedy where an individual, in this case a teenager, succumbs to the huge power of drug addiction and dies of an overdose. Here the teenager was Judge Kuhnke's adopted son, whose name was John Kuhnke. My references to John Kuhnke are only for purposes of context in my criticism, which is exclusively and directly aimed at Judge Carol Kuhnke. By no means I will ridicule John Kuhnke. In fact, I believe that this teenager, John Kuhnke, is another victim of Judge Carol Kuhnke's inherent ineptitude. On November 24th of 2016, Judge Carol Kuhnke and her family spent Thanksgiving holiday at her mother's house. Carol Kuhnke denied John permission to spend the night with his cousins because, according to Carol Kuhnke, she wanted things to be low-key this time, since John Kuhnke had just gotten out of the rehab facility 2 days earlier. Therefore, Carol Kuhnke, her partner, and John went back home at around 9 p.m. 1 hour later, at 10 p.m., Carol Kuhnke and her wife or girlfriend decided to go what Carol Kuhnke calls holiday shopping, thereby leaving John alone and completely unsupervised. Apparently, this erratic judge, Carol Kuhnke, had already forgotten that she wanted things to be low-key this time because of John's recent release from rehab. Now, all of a sudden, Carol Kuhnke just wanted to step out at 10 p.m. Erraticism, right? What are you going to do about it? So instead of allowing John to be in company of his loved ones, his cousins, his family, the pathetic judge left this vulnerable teenager in company of bottles of pills and bottles of alcohol. The narcotics and the alcohol were allegedly stored in Judge Kuhnke's tool chest with a lock, but that turned out to be useless because John was able to pry open the tool chest and gain access to the narcotics, vodka and rum that Judge Kuhnke was storing there. John took the narcotics and the bottles of alcohol and he went to his friend's house at around 11 p.m. Because of the weather in Michigan and how late it was, the fact that he went 5 or 6 miles away is indicative of how much John needed the company of somebody with whom he has affection. If it was not with his cousins because Judge Kuhnke didn't allow him, then it will be with his friend, now that Judge Kuhnke was lost somewhere. At some point, John overdosed, and once his friend realized, he called 911. This was a few minutes before 3 a.m. The paramedics and the police arrived at the friend's house soon thereafter, and they took John to the hospital. The police had to leave a voicemail to Judge Kuhnke because they were unable to get hold of her. And remember, this was at around 3 a.m., 5 hours after Judge Carol Kuhnke had gone low-key holiday shopping, as she wants to call it. Unfortunately, the hospital was unable to save John, who died sometime later. I feel sorry for John, and I feel sorry for his loved ones, his family, his friends. But I have no sympathy for Carol Kuhnke, because Carol Kuhnke is the type of judges who propagate crimes by leaving criminals unpunished under her rotten mentality that Michigan loves anybody who's powerful and that the rest of us have to stay out of the way. Remember, that is not just Carol Kuhnke's blatant statement in court on August 17th of 2016. That statement, which Judge Carol Kuhnke made so blatantly, is how she runs her judicial office. And because drug dealers, including those who contributed to John's addictions, are criminals and they are so powerful, they will benefit from this pathetic judicial mentality that Michigan loves anybody who's powerful. Subsequent investigations by law enforcement led to the conclusion that Judge Carol Kuhnke was in illegal possession of narcotics. It is illegal because Judge Carol Kuhnke knowingly possessed prescription drugs which were prescribed to people other than Judge Kuhnke or people from or members of her household. That is a violation of the Michigan Health Code. And this means that just as Judge Carol Kuhnke was administering oath to one of the assistant prosecutors in October of 2016, Judge Carol Kuhnke was knowingly stashing illegal drugs in her tool chest. So you thought that stashing illegal drugs and your alcohol in that tool chest was a great idea, huh? Busted! Yes, Judge Carol Kuhnke. Also, you have to follow the law. And we don't care that that pisses you off. It is so messed up when people like you are judges. It is interesting to point out that 3 days prior to the overdose tragedy, Judge Carol Kuhnke presided in the Washtenaw County Trial Court the session for the adoption day. I have no idea of what went on in that session, but it leaves me wondering whether Judge Carol Kuhnke went unprepared for that hearing, just like she goes so unprepared for many of the court hearings that she presides, or whether she was teaching the audience how to leave your adopted child alone and completely unsupervised so that you can go holiday shopping whenever you feel like it. Except for the extremely negligent individuals who think that a teenager's overdose is an acceptable outcome, here's a more responsible and precautionary measure for contexts such as this one. Hello, is this Child Protective Services? Yeah, hi, listen, this is Carol Kuhnke, Judge Carol Kuhnke. Judge, remember. So listen, I have an adopted son who is just 2 days out of rehab, and I am going to leave him alone and completely unsupervised in my apartment because I want to go with my wife or girlfriend holiday shopping. And yeah, I know it is 10 p.m., but I am bored out of my mind. Well, sir, with due respect, this is not a debate, so if you don't pick him up, that's not gonna be my problem. That's my ruling. And problem solved. CPS will have made some arrangement to protect this vulnerable teenager just fresh out of rehab, to protect him from the temptation of gaining access to the narcotics and alcohol that he knew Judge Kuhnke was storing in her tool chest. One number, one call, and Judge Carol Kuhnke chose not to make a difference. But here is an even better suggestion for Judge Carol Kuhnke. Instead of being out in the streets throughout the night up until the police could get hold of her, how about staying home and reading some of the motion briefs for the hearings that were scheduled for the next week. That way, Judge Carol Kuhnke will not be so unprepared for those hearings as she was for many or maybe all of my hearings in both of my lawsuits. As I have been explaining in the previous segments, Judge Carol Kuhnke was utterly clueless about the evidence I had been filing, and she was clueless about the motions which she was deciding at the hearings. This episode on February 24th, where Judge Carol Kuhnke asked me, "Is it true that you are not asking for emotional damages and blah blah blah?" is outrageous. The answer to her question could be found in the complaint and also in the motion which she was deciding at that time. We, the litigants, have to spend so much effort in doing legal research, preparing the evidence, drafting the motion, and then filing it in court. And then at the hearing we just get sloppy rulings, and then we find out that Judge Carol Kuhnke hadn't even glanced at the evidence, despite her misrepresentations that she was considering information that is material to her decision. Moreover, by staying at home and doing the work that she obviously wasn't doing in court, Judge Carol Kuhnke would have noticed right away if John is trying to get access to the contents of the tool chest, and thereby she will be able to prevent him from gaining access to these fatal substances. I said a few minutes earlier that Judge Kuhnke's possession of narcotics was illegal because some of those narcotics were prescribed to people that were neither Judge Kuhnke nor anyone from her household, and that constitutes a violation of the criminal provisions of the Michigan Health Code. The police report has a list of drugs and to whom they were prescribed, although in the case of Zolpidem, nobody was able to give an account as to its origin or purpose. However, it is obvious that the detective found it during his investigations. According to the police report, Judge Carol Kuhnke was storing her neighbor's medication upon his request because it appears that her neighbor was trying to protect his household, given that one of the members of his household may or may not have had a vulnerability to drug abuse, so he wanted to get rid of that danger. I'm not going to give any details about that aspect because it is not important, and pretend I don't have that page of the report. The point I want to make here is that Judge Kuhnke's neighbor did the right thing by getting rid of drugs that he no longer needs so as to protect his household. And just like it is smart to get rid of dangerous substances so that they are not a vulnerability in someone's home, it is likewise dumb to receive them, especially when someone in the receiver's household is having drug issues. It doesn't matter whether the receiver is a judge or has a tool chest with a lock. Juris Doctor does not entitle to Juris Drugstore. By the way, given that this neighbor is supposedly a close friend to Judge Kuhnke, Carol Kuhnke could have asked a favor to her close friend and neighbor to keep an eye on John while Carol Kuhnke was out doing her shopping. I mean, if Carol Kuhnke wanted so badly to go holiday shopping late that night. On December 16th of 2016, the Judicial Tenure Commission responded to my complaint or grievance against Judge Carol Kuhnke. It stated that after reviewing whether there is evidence of judicial misconduct, it found no basis for commencing formal disciplinary proceedings or taking any other action. It is outrageous that after Judge Carol Kuhnke endorsed Finley the Idiot's blatant attempt of fraud in 2015, after this judge prevented me for 3 months from taking the deposition of Al Pacha, after she ordered me to produce my tax filings since year 2009 as an irrelevant condition to be allowed to take the deposition of Al Pacha, after this judge ruled that I was allowed to take the deposition of Director Robin, but then she rushed to dismiss that lawsuit, After this, judge made her nefarious exposition of her rotten mentality that Michigan loves anybody who's powerful. After she made so many erratic and misleading indications to me, the litigant. After she gave the false and misleading impression that her rulings were based on information that is material, but then it was found out that she hadn't even glanced at the evidence or court documents, and after other incidents that I documented in my complaint in the Judicial Tenure Commission, now the Commission comes up with the unsupported conclusion that there is no evidence of judicial misconduct. With that blatancy by the Judicial Tenure Commission, it is going to be impossible to enhance the public confidence in the Michigan judicial system. Then on January 18th of 2017, the special prosecutor in charge of handling the incident of Judge Carol Kuhnke's illegal possession of narcotics sent a letter to the Judicial Tenure Commission reporting that incident. Again, the Judicial Tenure Commission did nothing about it. Because of how secretive and hermetic the Judicial Tenure Commission is, I have no idea of how often one same judge is the matter of grievances in the Judicial Tenure Commission, but it is notorious that Judge Carol Kuhnke has been reported at least twice in the course of just few months, less than 6 months, by two entities which are totally unrelated, for matters which are totally unrelated as well, and both of which have been very well documented. And yet the Judicial Tenure Commission doesn't touch this corrupt judge at all. Every now and then we hear that there's going to be a crackdown on Michigan corrupt judges and how the Michigan Supreme Court has issued new rules or directions to the Judicial Tenure Commission. But the fact is that people like Carol Kuhnke are allowed to remain in judicial office. During my 7.5 years of employment in Michigan, I earned and maintained an outstanding reputation, and I was always known for my outstanding work performance. It is not just a coincidence that I was rehired even after I had resigned in 2012. Then I lost my job as well as my prospective employment just because of false accusations by two rotten individuals. As easy as that. And as I took the matters to court, Judge Carol Kuhnke tried to put the blame on me by calling it reckless in reference to the proverb I wrote, and which is an element of the collective wisdom anyway. By contrast, Judge Carol Kuhnke engages in child endangerment with fatal and irreversible consequences. She engages in illegal possession of narcotics, is literally busted by a detective, reprimanded by a special prosecutor for that issue. She maintains her persistent incompetence in judicial office, and she is able to keep her court job. In February of 2017, the prosecutor filed a motion for recusal in two of the criminal cases presided by Judge Carol Kuhnke. The reason of these two motions for disqualification is that the detective who busted or made the conclusion that Judge Carol Kuhnke was in illegal possession of narcotics is a witness in either or both of those criminal cases. The prosecutor correctly noted that the continued presiding of these two criminal cases by Judge Carol Kuhnke is likely to have a detrimental effect on the administration of justice and/or the appearance of justice. This is because, given the circumstances, it is reasonable to conclude that Judge Carol Kuhnke may have a conflict of interest regarding the witness who happens to be the same person who busted her for illegal possession of narcotics. In fact, when the incident of Judge Kuhnke's possession of narcotics was discovered by law enforcement, the local prosecutor disqualified himself, and he requested the Attorney General to assign a special prosecutor to handle the matter of Judge Kuhnke's illegal possession of drugs. In doing so, the local prosecutor exercised his high standards of ethics, and he made a commendable effort to preserve the administration of justice by avoiding a possible conflict of interest of proceeding against a judge who presides cases where the prosecutor is involved. But whereas the local prosecutor had or exercised his high standards of ethics, Judge Carol Kuhnke didn't correspond to that. She denied both motions to disqualify herself. The defendant in one of these two criminal cases has pleaded guilty, and therefore the proceedings are practically over, thereby rendering the motion for disqualification a moot issue, whereas the other defendant apparently has some acquittance with Judge Carol Kuhnke, which constitutes an additional ground for suggesting that maybe the proper thing would be for Judge Carol Kuhnke to disqualify herself. But if Carol Kuhnke doesn't have the dignity to step outside of the case, even though a special prosecutor has told her there is sufficient evidence to file criminal charges against you, then Judge Carol Kuhnke is not expected to disqualify herself just because she has some acquittance with the defendant. In her order explaining why she is insisting to continue presiding this remaining criminal case, Judge Carol Kuhnke made several arguments which I, as an experienced litigant in her court, I'm able to spot as pretexts and nothing more than pretexts. For example, Judge Carol Kuhnke pointed out that that case will be tried to a jury, which is responsible for assessing the credibility of the witness detective. And therefore, because it is not Judge Kuhnke the one who will assess the witness's credibility, there is no conflict of interest. But that doesn't matter. The judge herself recognizes that she only has influence on whether the testimony of a witness is admissible or not. And we don't need to be at trial to have Judge Kuhnke impair the administration of justice. As I have been explaining, Judge Carol Kuhnke impaired the ascertainment of the truth over and over again in both of my lawsuits. And again, this was at the discovery process, not even trial. So likewise, she has tools for manipulating the value or the admissibility of the witness detective. Another pretext by this judge is her allegation that the prosecutor's argument is speculative because the prosecutor cannot even specify which party the judge might favor as a result of the bias. Guess what? That is irrelevant. The Michigan court rules do not require the moving party to choose between for or against when pointing to the judge's bias or possibility of bias. The only thing that matters is whether the judge's bias or risk thereof compromises the administration of justice or the appearance of justice. That's about it. In this particular situation, Judge Carol Kuhnke might be tempted to rule in a way or in an effort to earn the detective's sympathy in case the prosecutor decides to eventually file criminal charges against Judge Kuhnke herself, whether it is as a result of her narcotic situation or child endangerment or other issues that may arise. In the alternative, Judge Carol Kuhnke might rule in favor of defendant just for the sake of sabotaging or undermining the testimony provided by the detective who busted Judge Kuhnke. In either way, the administration of justice is compromised in this criminal case in particular. Therefore, it is childish, it is vexatious for Judge Carol Kuhnke to expect the prosecutor to play the game of forecasting in which direction Judge Kuhnke's bias will go. Here's yet another argument made by Judge Carol Kuhnke. People's or the prosecutor's assertion that defendant's due process rights might be adversely affected if the present motion is not granted is belied by the defendant's opposition to the motion. Again, irrelevant. The fact that the defendant's counsel or attorney opposed the motion to disqualify Judge Kuhnke means nothing. The lawyer was trying to earn Judge Kuhnke's sympathy and subsequently a favorable ruling. But in fact, many defendants in criminal cases go to the Court of Appeals raising the issue of ineffective assistance by counsel in an attempt to relitigate matters with the hope that, in the case of actual criminals, with the hope that there will be a mistrial in the subsequent round, or that the prosecutor might desist, but also in the case of innocent defendants, with the hope that the new attorney will raise the proper defenses and save that innocent defendant from unfair imprisonment. Here, the prosecutor was preventing a waste of, or he was trying to prevent a waste of judicial resources in the case that the matter went to the Court of Appeals, because Judge Kuhnke neglected to disqualify herself and she ended up compromising the administration of justice. And I know that, or I can understand the prosecutor's position, because in the criminal contempt proceedings I brought against Maria Vigers, I found myself advocating at some point for the process rights of this criminal Maria Vigers. But I did that because I wanted to preclude any grounds of appeals by which Maria Vigers could postpone, obstruct, or somehow impair the incarceration that she deserves for violating the personal protection order against her. So whereas the prosecutor was trying to avoid a waste of judicial resources, Judge Carol Kuhnke doesn't care about it. As long as she keeps getting her juicy paychecks, it doesn't matter whether the Court of Appeals gets clogged with cases from all the counties from other criminal cases. Regarding the criminal contempt proceedings I brought against Maria Vigers and my father's subsequent and fraudulent request for a personal protection order against me, both individuals filed false accusations of crimes in November of 2016 in their attempt to injure me. Given the similarity between their accusations and those accusations that Maria Vigers made in 2015 as she was sabotaging my employment at the University of Michigan, Judge Kuhnke's pretext for dismissing my lawsuit against Maria Vigers is disproved, because my father has never been diagnosed with mental illness or committed to a psychiatric unit, and yet he made the same type of accusations that Maria Vigers made when she was in the psychiatric unit and prior and after being released from there. Therefore, it proves actual malice in terms of defamation case law. For that reason, and also because my father propelled himself into the judicial setting by filing his request for a personal protection order, he basically waived the protective relief by which Judge Carol Kuhnke allowed him to avoid the deposition that I wanted to take of him. Additionally, as part of the pseudo evidence that my father filed in his attempt to injure me, he included emails from his former employer, Down Foods, which I had been trying to obtain via discovery in my lawsuit against Maria Vigers. That is another waiver by my father of the protective relief that Judge Kuhnke unduly granted to him. Given these circumstances, I filed a motion in the Court of Appeals for the purpose of adding this new evidence, because this is fundamental to some aspects of the appeal and the lawsuit against Maria Vigers. These new filings by my father and by Maria Vigers in November of 2016 constitute newly discovered evidence which is relevant enough to merit a reversal of multiple rulings made by Judge Kuhnke in my lawsuit against Maria Vigers. Given that the jurisdiction at that time was in the Court of Appeals, I filed in the Court of Appeals my motion to add the newly discovered evidence with an explanation of how it is relevant to crucial aspects of my lawsuit. As in trial court, whenever a party files a motion in the Court of Appeals, the other party has a deadline for filing his answer. Finley the Idiot never filed anything in the Court of Appeals other than his appearance, which is a one-page statement announcing that he's going to represent Maria Viggers in the appellate process. Instead of any answer by Finley the Idiot in opposition to my motion, Judge Kuhnke intervened improperly, of course. How else could it be? And by that intervention, Carol Kuhnke attempted to disrupt my appellate process by saying that there was no final order issued in my lawsuit against Maria Viggers, and therefore she was issuing a supposedly final order that closes that case. When initiating an appellate process, the appellant has to file multiple documents. One of them is the final order, the order by which the judge closes the lawsuit in trial court. Of course, I met that requirement since the beginning. Judge Carol Kuhnke's intrusion in my appellate process in the form of her blatant lies was alarming, because that would have prompted the Court of Appeals to strike my appeal or to postpone the review of my case several months. Therefore, I immediately filed in the Court of Appeals evidence that disproves this judge's false statements by filing an excerpt of the transcript of the hearing on March 16th of 2016, which shows Judge Kuhnke's apparent rush or hurry to sign the final order so that she could abandon the courtroom. And I also filed again two versions of the final order, one of them signed by this judge's corrupt hand, and the other one with the seal showing the judge's name and her attorney number. Additionally, Judge Kuhnke's intrusion in my appellate process violates the Michigan court rules. One of these rules is clear in that once the record of the case is transmitted to the Court of Appeals, the trial judge cannot keep meddling with the record of the case. In this matter against Maria Viggers, the record of my case was transmitted to the Court of Appeals in July of 2016, whereas this judge was meddling with the record of this lawsuit in early 2017, that is, about 6 months after the record was transmitted to the Court of Appeals. This evidences how Judge Carol Kuhnke isn't satisfied with obstructing justice in her courtroom. She also needs to obstruct justice even when she does not have the jurisdiction of a case. Even when the jurisdiction is in a superior entity, such as the Michigan Court of Appeals. I can't believe how obsessed this crook Carol Kuhnke is when it comes to impairing the administration of justice. Eventually, the Court of Appeals denied my motion, and therefore my next alternative was to file the newly discovered evidence in trial court. In my motion in trial court, I specified the Michigan court rule which Judge Carol Kuhnke had violated and which I was asking her not to violate again. The motion brief reproduces an excerpt from a treatise which discusses a conflict between that court rule and the Michigan court rule which addresses the setting aside of a judgment because of newly discovered evidence. In few words, the conflict discussed in that treatise is the uncertainty as to how to proceed if the new evidence is discovered at a time when the jurisdiction of the case is not in the trial court. And that was exactly the situation here. When Maria Viggers and my father resumed their unlawful attempts to injure me, the jurisdiction of my case was in the Court of Appeals, not in trial court. When there is a conflict between two or more Michigan court rules, the entity in charge of clarifying how to proceed in that type of scenarios is the Michigan Supreme Court, not some despicable trial judge who repeatedly favors criminals. By reproducing that excerpt, I was demonstrating my awareness that it would be improper for this corrupt judge to make any ruling on my motion prior to the completion of the appellate review. Additionally, I pointed to Michigan case law, which discusses the unfairness of making a ruling on a motion for which there has been no opportunity for a hearing. And that was the situation here. Because the appellate review was still pending, it will make no sense for me to even schedule a hearing in trial court. Given these compelling reasons, do you think this time Judge Carol Kuhnke respected the court rules and refrained from obstructing justice? She didn't. Judge Carol Kuhnke rushed to deny my motion with the stupid pretext that she didn't have jurisdiction of the case. And I say this is a stupid pretext because in my motion brief I have made it so clear that I was aware that she didn't have the jurisdiction and therefore she should not rule on the motion at least prior to the completion of the appellate review. Basically, I told this corrupt judge, you don't have the jurisdiction, so keep your hands off my case for now. But she didn't care. She simply cannot stop, she cannot resist obstructing justice. That is another layer of Judge Carol Kuhnke's blatancy and her absolute lack of principles. By the time this corrupt judge rushed to deny my motion, she had been so lucky that the prosecutor decided not to file any criminal charges against her because of her illegal possession of drugs. She was lucky that the Judicial Tenure Commission did nothing about the incident. She was aware of the two motions to disqualify her from the criminal cases where the witness was precisely the detective who busted this judge for illegal possession of narcotics. She was also aware of the grievance that I filed against her in the Judicial Tenure Commission, thereby suggesting that I am willing to denounce any and all judicial misconduct by her. She might have been aware also that her narcotics situation was being publicized in the media, and she was also aware, because of my motion brief, of all the court rules, case law, and principles of justice that she will be violating by rushing to deny my motion. And yet she didn't care. She just went ahead and issued her new obstructing ruling. That is another example or another side effect of what happens when unlawful conduct is left unpunished and persistent incompetence remains unaddressed. The person who committed the unlawful or inequitable act continues violating the laws, and in the case of judges like Carol Kuhnke, continues deliberately violating Michigan court rules and contravening legal precedent that remains valid in the jurisdiction. From what I gather by reading the police report from November 25th of 2016, or the incident that happened on that day, Judge Carol Kuhnke should be responding as a defendant to the charges for reckless endangerment of a child as well as for illegal possession of drugs. Based on my litigation experience, Judge Carol Kuhnke should be prosecuted for obstruction of justice as well. Just because Carol Kuhnke is a judge, that doesn't mean that her sloppy rulings constitute sound discretion, especially when those rulings severely impaired the ascertainment of the truth in both of my lawsuits. Carol Kuhnke, the sickly visage of non-stop judicial debauchery, the soft-spoken monstrosity that doesn't care if your rights are violated, no matter how flagrantly they are violated, the perverse judiciary that ends up siding with the criminals and individuals who commit offenses. Since the Judicial Tenure Commission refuses to do its job regarding Judge Carol Kuhnke, the following invitation is open to everyone, regardless of whether or not you are a pro se litigant. If you come across with any instance of judicial misconduct by Carol Kuhnke and you have reliable documents or records to prove the issue, please feel free to contact me and we will prepare a public denouncement. It can be posted in this platform or in any platform of your choice. All I need is that you be willing to share with the public reliable sources so that the audience is able to verify by itself this judge's perversity and incompetence. As you have seen in my brief discussion about the criminal case that Judge Kuhnke insists to preside, Sometimes an opinion or order drafted by this pathetic judge is sufficient to exhibit her perversity and her obstinate conduct in court. Beware that Carol Kuhnke has warned that she plans to perpetuate herself in judicial office, when in fact people like her need to be removed from judicial office. Another relevant aspect from the discovery that Judge Carol Kuhnke was committing her drug-related crime is the fact that her adopted son had a mental illness, anxiety, and was bipolar. This is relevant because when Judge Carol Kuhnke dismissed my lawsuit against Maria Viggers, Judge Kuhnke resorted to poorly thought allegations about the mental illness that Maria Viggers undeniably suffered, as Judge Kuhnke worded it. The information that Judge Kuhnke was domestically and intimately involved in a situation of mental illness renders her unable to impartially preside a case where the defendant resorts to the belated pretext of mental illness in an attempt to get away with the defendant's unlawful conduct. The fact that Judge Kuhnke distorted the elements of a prima facie case of defamation is evidence of how biased Judge Kuhnke is in favor of a defendant with allegations of mental illness. In fact, when people are evaluated for the possibility to participate in a jury, each candidate is asked whether the candidate has had any involvement in a situation similar to the one for which that jury is being set up. And if the candidate declares that he has had such involvement or that he has strong views about the matter, that candidate is discarded because it is presumed, and with good reasons, that the candidate will be unable to decide matters impartially and in accordance with the law. Here the difference is that Judge Kuhnke always concealed from the litigants in this lawsuit the fact that some private situation of hers will or might render her unfit to continue presiding this lawsuit. Judge Kuhnke didn't have the honesty to at least allow the litigants to raise the issue of her possible unfitness for presiding this case. Just a few weeks before the Court of Appeals reviewed my cases, I noticed another one of Judge Carol Kuhnke's delusions. For some strange reason, Judge Carol Kuhnke thinks or used to think that she works at the University of Michigan since 2015, as reflected in her Facebook page. Of course, that is entirely false. Carol Kuhnke is not in the list of employees of the University of Michigan, neither in 2015 nor in subsequent years. That is just a product of this judge's imagination. However, that is also a matter of concern, because a judge is supposed to conduct fact-finding, especially in cases where there is no jury, such as both of my lawsuits. When a fact-finder has that type of delusions, he or she clearly is unable to conduct a competent fact-finding on matters that are much more complex than the naming of an imaginary employer. The fact that Judge Kuhnke's imaginary employer is the University of Michigan helps explaining why this judge unduly favors the university by allowing it to continue concealing from me documents that are utmost important in both of my cases, even though Judge Kuhnke knew or should have known that the University of Michigan engaged in discovery fraud. It also helps explaining why Judge Carol Kuhnke never cared to address the multiple inconsistencies and contradictions by the university employees who testified at the deposition. And remember, a deposition is a testimony under oath. Therefore, this judge should have made at least some effort to ensure that the witnesses testify to the truth and proceed accordingly if they do not. It is obvious that Judge Kuhnke didn't want to bother or to importune her imaginary colleagues. But this issue is another sign of the fallacy of this judge's charlatan speech, that her rulings are based on information that is material. Judge Kuhnke's rulings are based on information that is material to her corruption and material to her delusions. This issue reminds me of the occasion when President Donald Trump tweeted Covfefe, and which made him the target of so much criticism and mockery. But whereas President Trump removed his tweet within 5 hours, it took more than 2 years for Judge Carol Kuhnke to remove from Facebook her delusional post. Judge Carol Kuhnke works at the University of Michigan under the same mental state with which President Donald Trump Covfefes. As I am recording these videos, my 2 cases that Judge Kuhnke sabotaged are in the Michigan Supreme Court. I am very proud of the briefs I have filed in that court. I consider them to be robust and very well supported by Michigan case law, as well as compelling authorities from other jurisdictions. However, at this point, sometimes my litigation, or this phase of my litigation, feels like an uphill battle because of the manifested friendship between Judge Kuhnke and Justice McCormack, combined with Judge Kuhnke's nefarious mentality that Michigan loves anybody who's powerful and that the rest of us have to stay out of the way. I recently found a statement made in 2013 by Justice McCormack in reference to Judge Kuhnke, stating, "I don't think I know a more hard-working, compassionate, or even-handed person." As a litigant who has had the unfortunate experience that his lawsuits are presided by Judge Kuhnke, I can certainly refute Justice McCormack's exaggerated statement. Because one thing is to meet someone at a golf tournament, and another thing is to meet that person when we are under so much hardship that we need to approach the court in our pursuit of justice. What follows is my respectful refutation to Justice McCormack. Justice McCormack, I appreciate your generosity in trying to boost the mood during a ceremony for one of your colleagues. However, I am sure that you certainly know people who are more hardworking than Judge Carol Kuhnke. I don't know nearly as many people as you do, and even I know persons who are much more hardworking than Carol Kuhnke. Some of them are my relatives, from my mom's side, of course. Maybe the only person who didn't know someone more hardworking than this judge was John Kuhnke. He might have been able to, eventually, had Judge Kuhnke been more compassionate. But Carol Kuhnke isn't compassionate. She left this vulnerable teenager in the company of drugs and alcohol instead of leaving him in the company of his loved ones. There is no doubt that our loved ones are able to provide a much better companionship and much better care than a tool chest with a lock. We all know the tragic consequence of that lack of compassion. Judge Kuhnke wasn't compassionate in my lawsuits either. I have been injured in my reputation and in my career and source of income as a result of fraudulent statements that 2 malicious people made. Judge Carol Kuhnke didn't care. In one lawsuit, she suddenly abandoned the courtroom as I was shocked by her miscarriage of justice. In the other lawsuit, Judge Kuhnke blatantly told me that it is not up to her to compel the defendant to clarify his defamatory statement. Carol Kuhnke is only compassionate to herself. Maybe that is when she decides to take her antidepressants, go holiday shopping, or make delusional posts. Carol Kuhnke isn't even-handed either. Being even-handed does not mean to reach the middle point between a criminal and a victim. That is not even-handedness. That is just suppression of the criminal's liability in detriment to the victim. To be even-handed, a person needs to start by recognizing that sometimes the victim hasn't been able to resume his career or his lifestyle, whereas the criminal continues enjoying the same prerogatives that he was enjoying ever since he committed his unlawful activity. Moreover, when Judge Carol Kuhnke sides with a criminal or a tortfeasor, Judge Kuhnke affects not only the victim, but also the victim's family. Because the family suffers when the victim suffers. The family suffers when they see that the victim is dealing with a judicial system that really doesn't care about administration of justice. Again, I understand your benign intention in making that exaggerated statement, but Justice McCormack, please make no mistake. Judge Carol Kuhnke is a disgrace to the judicial system.